Coming up today on the Nick Craig Show, a mixed result from the United States Supreme Court on a couple of major cases dealing with birthright citizenship, protecting women's sports, and campaign finance. We'll get into all the details coming up. And a good Wednesday morning to you. Welcome into the Nick Craig Show, streaming live this morning on YouTube, Rumble, X, and Facebook. Don't forget that you can take the show with you 24/7 on demand in your favorite podcast app. It's totally simple and easy and free to do. Just search for the Nick Craig Show, tap the subscribe or follow button, and you'll take a new program with you each and every weekday morning. You can also listen online by visiting the website nickcraig.com. Our show this morning brought to you by the Law Group here in Wilmington. Visit them online, lawgroupnc.com, and our show notes, as always, over at patreon.com/Nick Craig. There, just to kind of start off, we're not going to dive into all of the detail or really any of the detail today. The state of North Carolina has officially unveiled a state budget. I'm expecting some pretty interesting debate on the floor of the North Carolina House and Senate today. And so if that materializes, we'll be talking about that tomorrow morning, and I'll bring you some of the arguments being made for and against the budget. So that has happened. Major statewide news, a state budget. There's a great piece over at carolinajournal.com walking through all the details. We'll hopefully, and my plan is to dive into that tomorrow morning, unless, of course, some other major story, some other big news happens. We'll be diving into that tomorrow morning right here on the Nick Craig Show. Tuesday was a very busy day in Washington, D.C., as June 30th marked the end of the United States Supreme Court's current term, and we saw decisions on a variety of different cases, and what I will describe, and I think what many are calling, on both sides of the political aisle, funny enough, a mixed bag of results. Some wins for conservatives, some wins for those on the more liberal side of the political aisle, dealing with things like birthright citizenship. That was a big loss, I would argue, for the nation as a whole. However, the Supreme Court pretty handedly coming in and saying, hey, we need to protect female sports, right? There's this thing called Title IX, and this novel new concept. Maybe you've heard of it in the past. And so we need to protect women's sports. That was a major win, and some pretty big campaign finance decisions as well, as we'll get into all of those details. Let's start off with birthright citizenship, which I think is probably, in terms of the overall future of the United States of America, probably the biggest decision from the nation's high court yesterday. Now, as I already mentioned, the ruling dealing with transgender sports is a major one, and we're going to talk about that in great detail here today. But in terms of the overall trajectory of the nation, the overall path forward that we are charting, this birthright citizenship discussion and now ruling from the United States Supreme Court is one that should be troubling to you, something that should be concerning to you. Let's just lay out, before we get into some of the details, what's going on here with birthright citizenship. People across the globe come into the United States under false pretenses. I'm not saying illegally. I'm saying they come into the United States under false pretenses, have a child in an American hospital. Their child, under birthright citizenship, is now a U.S. citizen and essentially becomes what is called an anchor baby, so that not only the parents, but other family members can eventually make their way to the United States. It's the reason why countries all over the globe literally have companies and individuals that run what they call birth tourism, where individuals pay pretty significant amounts of money. This is very popular over in China, to set up this system and set up this process where you have your child, you give birth to your child in an American hospital, not as a U.S. citizen, as a foreign individual traveling to the United States, and your child therefore is a U.S. citizen. That was the question that the United States Supreme Court, the nation's high court, was asked to rule on. And unfortunately, they ruled that any child born, or any person born on U.S. soil, which obviously would be a child, under the 14th Amendment is an American citizen. Some of the details over at the Federalist: the United States Supreme Court ruled on Tuesday that children born to illegal aliens and foreigners traveling to the United States through birth tourism on U.S. soil are citizens under the 14th Amendment. Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch dissented. However, while Justice Brett Kavanaugh concurred in the court's judgment and dissented in part. This case, known as Trump v. Barber, came to fruition last year when the president, President Trump, signed an executive order barring the federal government from producing or accepting certain documents purporting to recognize these birthplace citizens. The directive was immediately challenged, no surprise there, in courts by proponents of granting citizenship to children of illegal aliens and those traveling to the United States simply to have a child that were born on U.S. soil. Writing for the majority, Chief Justice John Roberts ruled that that children born to parents unlawfully or temporarily present in the United States satisfies both elements of the 14th Amendment Citizen Clause, noting they are born in the United States and subject to the jurisdiction thereof. Therefore, he reasoned, they are citizens at birth under the United States Constitution. The Chief Justice and John Roberts went on to say, citizenship then and now was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every freeborn person in the land. We keep that promise today. So it's interesting because if you look at the clear verbiage of the 14th Amendment, I actually don't disagree with what Chief Justice John Roberts wrote. Right, because the 14th Amendment essentially says if you're born on U.S. soil, you're a U.S. citizen. However, I think it is important to note, and it does kind of rub me the wrong way, that in his majority opinion, he writes, the framers of the 14th Amendment extended that promise. I don't think, and I feel like I can say this pretty confidently, I don't think the framers of the Constitution, as we approach America's 250th anniversary coming up this weekend, I don't believe that the framers had in their minds that Chinese nationals would be coming to the United States of America simply to have a child that they could turn into an anchor baby and then bring their entire family to the United States. I don't think that the framers had in mind the concept or the idea that individuals would cross into the United States illegally from portions of Mexico and South America simply to have a child on U.S. soil, therefore bringing them and their entire family to the United States of America. So he can say, and he obviously has the ability in his position to say that as I read the 14th Amendment Citizenship Clause, this is how I understand it. That's fine. I may disagree with his opinion, but to then say the framers made this point, I think is very disingenuous. We're not talking about individuals that are just randomly having babies, randomly having children here in the United States. No, we are literally talking about a cottage industry all over the globe where individuals come to the United States exclusively for the reason to have a child, to have birth, to give birth in an American hospital. I don't believe, truly do not believe, that was ever envisioned or intended under the 14th Amendment. Call me crazy, call me wrong. I just don't think that's what the framers thought was, yeah, you can, carry a child for the vast majority of the, obviously the term of the pregnancy, and then just come to the United States in the last 3 or 4 days, come in on some BS tourism visa or whatever, and then have your child in in the country in an American hospital. I really, really don't think that was the case. Justice Ketanji Brown Jackson, and it was honestly pretty surprising that she was able to rule on this because she doesn't even know what a woman is, authored a concurring opinion with Justice Sonia Sotomayor joining in part as the Biden appointee specifically criticized Justice Thomas's dissenting opinion and the government's position as one that proposes a return to the core tenet of the Supreme Court's 1857 decision, the very popular Dred Scott versus Sanford decision, which held that Black Americans, whether freed or enslaved, were not U.S. citizens. In his concurrence, Kavanaugh said that Trump's executive order did in fact violate federal law, but noted it was not the 14th Amendment. In agreeing with the dissent, he said that there is no constitutional birthplace citizenship right and noted that Congress could, consistent with the 14th Amendment, amend the law or otherwise enact new legislation establishing exceptions for birthright citizenship for children born to foreign citizens unlawfully or temporarily in the United States of America. So as I mentioned at the top, a very mixed bag set of rulings from the United States Supreme Court. We'll get into some more detail here in just a minute. Back to the United States Supreme Court, a series of decisions coming forward on Tuesday as the nation's high court rounded out their Supreme Court term on June the 30th, as we've now flipped the calendar over to the month of July. We're talking about the ruling on birthright citizenship from the High Court, in which the majority of that court, all three of the liberal justices, no surprise there, alongside Chief Justice John Roberts and Amy Coney Barrett, joining the majority opinion there, saying that the United States' 14th Amendment essentially guarantees birthright citizenship. That's how they read it and understand it. I just read some of the commentary there from Justice Kavanaugh, who said, hey, there's no such thing as birthplace or birthright citizenship in the United States Constitution. If this is something that the United States government wants to offer, they can, but they're going to have to go through the process, as they should, in Congress, of passing legislation that would enshrine this in law. You can't just make this up and assume that this is what's going on. In a blistering dissent, Justice Thomas, who was joined by Gorsuch, blasted the majority's account for not being historically accurate, as he emphasized that the court's decision adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for freed slaves, but is now instead been repurposed for political protections that Congress did not support. And I'm very glad to see that opinion from Thomas and Gorsuch, because that's exactly what the 14th Amendment was. I mean, when you look at what the intent was, what exactly was going on with the 14th Amendment, that was it. This was for former slaves who had then been freed and their children. That was the intent. That was the purpose of the 14th Amendment. Plain and simple. It was not for, again, Chinese nationals to book a flight to the United States and get some garbage vacation visa coming into the United States and then popping out a baby in an American hospital. That was absolutely not the intent of the situation. According to the justices, Thomas and Gorsuch, they wrote, "I am not sure that today's opinion will stand the test of time. The citizenship clause added greatly to the dignity and glory of American citizenship. Today's opinion devalues that citizenship. I respectfully dissent." Very strong, and I would argue very chilling words there from Justice Thomas, saying that, this essentially cheapens what it means to be an American citizen. In describing the case as one of the most important decisions in the history of the court, Justice Samuel Alito noted in his dissent that the majority's ruling is a, quote, serious mistake, end quote. He underscored how holding that virtually everyone who happens to be born in the country grants citizenship to the children of birth tourism. noting women who come here solely for the purpose of giving birth to a child and then promptly return home. Contrary to the court's ruling, he said, the 14th Amendment confers citizenship only on those children who, at birth, owe allegiance solely to this country. He went on to say, the court's interpretation preserves a powerful incentive to enter or remain in this country illegally. Immigrants naturally prefer affluent countries where economic opportunities are available. Other than Canada, the United States will be that only affluent nation where births alone is enough to establish citizenship. If the 14th Amendment required these results, the country would have to live with them or amend the Constitution. But the 14th Amendment does not include the rule that the court now imposes on the country. In my judgment, the court has made a mistake that will seriously affect our country in the future. Gorsuch also authored a short dissent explaining why he and Thomas's view of the citizenship clause is consistent with the Supreme Court's 1898 ruling U.S. versus Wong Kim Ark decision, which held that the children of lawful permanent residents of America are citizens. He also outlined why the respondents' facial challenge to Trump's executive order must fail. Regardless of the commentary here, not to take anything away from it, not to cheapen the commentary from Justices Clarence Thomas, Samuel Alito, and Neil Gorsuch, because in large part I'm in full agreement with them, but not to cheapen it. It doesn't matter, and that's the way that the courts fell on this issue. The justices, the liberal justices, obviously on the winning side of this issue, no surprise. Pretty disappointed in Chief Justice John Roberts and Amy Coney Barrett, though, because as I mentioned at the open, you talk about a court decision that will have a huge lingering impact for the United States of America for decades going forward, for future generations. This is one of those major decisions, right? The United States Supreme Court only takes up, the most important cases. We know this. Right? That's why in their entire term, there's only a handful of major rulings that we see. There could be a case to be made, and I might make the case that this is the biggest ruling of this term, in which now, moving forward, any other nation, any other country across the globe, any other person across the globe now has an incentive to set up a situation where they give birth in the United States of America. And it's so funny, right? Just kind of a quick aside, the Democrats who hate the United States talk about how awful and terrible our country is, yet will applaud this decision. These are the people that talk about how they need to flee the United States of America because it's so oppressive, right? You hear this from the left all the time. Yet they are cheering for and are happy with a ruling that essentially greenlights individuals to come to the United States of America solely for the purpose to have a child, to give birth to a child, right? Those two things can't add up. If the United States of America is this awful, terrible, oppressive regime that we are told to believe, if that is all true, if that is all fact, and right, you see Rosie O'Donnell and the rest of these clowns jumping ship and moving over to Europe, which have at it. If that was all the case and all true, why is this such a cottage industry? Why is this such a big thing that is going on? Well, of course, as the justices in the dissent noted, because the United States of America offers more opportunities and has offered more opportunities to more people than any other society that has ever existed in world history. Plain and simple. That's why. That's why people want to come here. And so while this is a disappointing decision from the high court, the administration has already responded saying that they are going to be taking a look at their screening protocols for individuals that are coming into the United States potentially on false pretenses simply for the purpose of having a child on U.S. soil. So we'll probably see some additional back and forth between the United States federal government, the Trump administration, and this ruling. Will be keeping a very close eye on those details. Not necessarily a win for conservatives at the high court yesterday, at least on this issue. However, the Supreme Court did uphold laws protecting women's sports. We'll get into those details coming up here in just a couple of minutes right here on the Nick Craig Show. Before that, I want to tell you about the law group here in Wilmington and thank them for their continued support of the program, and remind you that when legal challenges arise, make sure you put your trust in the law group in Wilmington. Since 2003, their experienced attorneys have provided high-quality, affordable legal services across eastern North Carolina. Whether you're facing a divorce, navigating a real estate transaction, or maybe you're in a position where you need a strong defense, no matter the issue, no matter the question, the law group has your back. Their dedicated team ensures your questions are answered and issues are resolved as quickly as possible. Great news, folks. They're located in downtown Wilmington and just a phone call away at 910-251-6088, or you can visit them online at lawgroupnc.com. That's 910-251-6088, or online lawgroupnc.com. It's the Law Group. Experience and dedication you can rely on. We appreciate the Law Group and their continued support here of the Nick Craig Show. All right, quick break. We'll talk about protecting women's sports and a couple of the other major decisions from the United States Supreme Court as the Nick Craig Show continues, streaming live this morning, 7 a.m., YouTube, Rumble, X, Facebook, and available 24/7 wherever you get your podcasts. And a good Wednesday to you. Welcome back to the Nick Craig Show. Don't forget you can get access to our daily show notes and more by visiting patreon.com/Nick Craig. Also access to our monthly Patreon Hangouts. That'll be coming up here in a couple of weeks as we get towards the middle and end of July. We are talking about a litany of decisions from the United States Supreme Court yesterday as they ended their official judicial term on June the 30th, handing down a mixed bag of rulings arguably for both sides of the political aisle. Liberals happy with some of the opinions, not others. Conservatives, same thing. They're happy with some opinions, not happy with others. Let's move on to women's sports. This was a major ruling from the United States Supreme Court as the nation's high court upheld that state laws, like we have here in North Carolina, protecting women's sports from transgender athletes, so-called transgender athletes. In the 6-3 ruling, it was no surprise there, completely along ideological lines. The decision stems from a case known as Little v. Hayok and West Virginia versus BPJ, which dealt with challenges brought against Idaho and West Virginia's laws ensuring fairness for female athletes. Writing in the majority, Justice Brett Kavanaugh ruled that state law permitting schools to, quote, determine eligibility for women and girls sports based on biological sex do not violate the 14th Amendment's Equal Protection Clause or Title IX, which of course is the irony in all of this. He emphasized that separate sport teams for biological males and biological females are reasonable. Can you believe, quick aside, can you believe that we're at a period of time where a United States Supreme Court justice is having to write that it is reasonable for men and women to have sports leagues that are separate? I mean, it just goes to show you how screwed up things are right now, where that is something that has to be authored, not by a random judge, but the Brett Kavanaugh, who's a member of the United States Supreme Court. He went on to say, not only is it reasonable, given the inherent physical differences between the sexes, allowing only biological females to play only on women's and girls' teams can reduce the risk of physical injury and ensure fair competition. He went on to say the two states here, along with 25 other states, have concluded that at this time that women and girls should be allowed to compete for those life-changing opportunities on an equal playing field without the fear of physical injury from biological males or being forced to compete against biological males. Consistent with Title IX and the Equal Protection Clause, we hold that states may maintain women's and girls' sports for biological females. They may determine eligibility for women's and girls' sports based on biological sex. The Constitution and Title IX do not require an overhaul of women and girls' sports throughout America. This is a story that's got some pretty big statewide connections as well, even though North Carolina was not part of the lawsuit. And the reason that this happened, that if the name Peyton McNabb sounds familiar to you, she was in the news a couple of years ago, back when I was still doing mornings here doing mornings in Wilmington. She actually joined us on the show a couple of times. She was a volleyball player out in Western North Carolina, and she was pretty severely injured after a dude, a biological male, was playing against her on the volleyball court. And so that has sparked and was one of the reasons why many of these cases rose to the point that they are at right now. I've always appreciated reading Peyton's work. She is a phenomenal ambassador for female and women's sports across the United States. She was on Fox News yesterday, shortly after this decision was announced. And so to hear this directly from a female, a woman who was wanting to play female sports, was wanting to participate with other women in sports, in the case for what she was playing, volleyball, this was a really cool moment for her. Take a listen to this.
I'm going to introduce now Peyton McNabb, Independent Women's Forum ambassador, former three-sport high school athlete from North Carolina, severely injured by a biological male on the women's volleyball court. Good morning to you, and congratulations. You won.
Good morning. Thank you so much.
How do you feel now?
I'm just feeling so blessed. Of course, this is something that means a lot to me, and it affected me personally. And, there's a lot of eyes on this across the country. There's families, there's parents, and there's coaches and daughters who are watching this decision being made. And I'm just so thankful that they get to understand that they are protected and it's okay for their state to protect them, because that's all it was. All that they were having to determine is if it was okay if states could protect their girls or if it was allowed. So I'm thankful that states are able to protect their girls. Of course, they shouldn't have been put in that position to begin with, but again, this really does help the Supreme Court, because to me, if they wouldn't have ruled this way, they would have lost all credibility. So I'm very thankful it went this way, and I'm excited to see it keep pushing in the right direction.
Peyton, I just want to mention, one, that it's great to see you again. And I remember years ago when you came on with your dad. And, a lot of parents have fought very hard for their girls. And I'm curious about your feelings in terms of, their love and support for you and their willingness to stick up for you when this was happening.
Yeah, this is really a full circle moment because you guys were the first interview that I ever had. So this is really a full circle, but my dad has been with me through all of this. My whole family has, my community, my sister. Like, this has been an insane thing that happened to us, and it's happened all around, and it's not just me at all. It's not a unique experience, and so many families, so many moms and dads they've just felt so helpless watching their daughters struggle, right, being put in this it seemed impossible situation. So to see where we're at now versus where we were when this first started, when I first met you guys, I mean, it's just an insane progress that we've made, and I'm incredibly thankful and blessed to have had parents who cared so much about me and pushed me to keep fighting until we got to some good news.
It's been interesting to watch you grow up. Thank you, Peyton, for your time.
Proud of you.
Yeah.
Really cool, and as Peyton there noted, kind of a full circle moment when her story sprung into the national spotlight. I'm trying to remember when this was. Sometime probably in 2023 or 2024, maybe 23, when this story first broke. Again, kind of backing up a couple of the things that she said. What an insane position that we're even at where we're having this discussion. An insane situation where we are having to discuss whether women should have the ability to freely and fairly participate in sports. I mean, it's nuts that we're at this point. While joining the majority in the full, Justice Clarence Thomas authored a concurring opinion outlining 2 additional points. He went in on this. He reiterated that transgender is not a suspect class, a point that he and Justice Samuel Alito and Amy Coney Barrett raised in a court decision last year, and underscored the importance of acknowledging biological reality. This was a very strongly worded claim here from Justice Thomas, saying men and boys with gender dysphoria are not women or girls, even if they believe that they are. Sex is an immutable biological characteristic. It is binary, and man and women, boys and girls are terms that correspond to adults and children of each sex. To use language to obscure reality to show indifference regarding the truth is to lie to the public and cease to treat our fellow citizens as equals. Wow. An absolutely scorching opinion from Justice Clarence Thomas, saying what I think most people are probably afraid to say. There's no such thing, as he says, with men and boys, people with gender dysphoria. You're not a woman. You're not a girl. You're a dude. You're a biological male. We have gotten so wrapped up in these terms, so wrapped up in these phrases, and it's become such a polarizing issue that, God forbid, you make that statement. God forbid you point out that, hey, just because you're pretending to be a girl today, just because you put on a dress today or claim that you're a woman, doesn't actually make you one. And vice versa. If you're a woman claiming to be a guy, you're not. And just claiming it, saying it out loud, or putting your pronouns in your LinkedIn bio doesn't change your biological sex. But this is the discussion that is happening right now in the United States of America, and it's totally nuts, totally crazy. But fortunately, the United States Supreme Court, in this 6-3 decision, this 6-3 majority, came down, no question about it, on the right side of the issue. We are talking about some of the decisions from the United States Supreme Court yesterday as they rounded out their court session, specifically now dealing with protecting female sports. We've read through some of the majority opinions in this 6-3 ruling. However, there, as I mentioned, 3 dissenters, no surprise there. It was the 3 liberal, 3 Democrat justices on the court. Justices Sonia Sotomayor wrote in part in the dissenting opinion, playing sports can lead to benefits that are immeasurable, and many are understandably invested in earning that competition that stays fair and safe. Because the majority, however, inflicts a hardship on those it disfavors without giving them the fair and full opportunity that the Constitution requires to litigate to their constituents, I respectfully dissent. While joining Sonia Sotomayor's opinion in full, Justice Ketanji Brown Jackson, who I'm not sure how she didn't recuse herself from this case, not being able to describe what a biological woman was, wrote separately to advance trans ideology. In joining leftist jargon, she argued that Title IX makes room for individuals to live in the gender they choose. It cares not just about sex assigned at birth, but also individuals' ability to match or not match their gender presentation to their gender identity. You will not find a more woke, progressive, left-wing nut than Justice Ketanji Brown Jackson. You won't. And the fact that she, in an official document from the United States Supreme Court, claims that Title IX, which the whole premise of Title IX was to make sure that women and females in middle and high school and colleges had the same or equal opportunity to participate in sports as men do. Obviously, men's sports were a lot more popular. Women's sports did not receive very, if any, funding at all. That was the whole premise of Title IX. The fact that she claims that that gives individuals to live in, quote, the gender they choose is totally nuts. Totally nuts. But I guess necessarily we shouldn't be surprised there that the liberal justices on the nation's high court absolutely fell along ideological lines. This is another major ruling from the court, and it's one that makes complete and total sense to anybody and everybody. And hopefully we'll see more states. There's already 25 that have these policies in place, including the state of North Carolina, doing something that I assumed wasn't very controversial, protecting the ability for women and girls to participate in sports. I mean, all the stories that we've seen over the last couple of years, I mean, I just saw one this week where you have biological men pretending to be women, putting on a dress, claiming to be a woman, that are just absolutely smoking all of these other females in these competitions, beating them in races and in swim meets by huge leaps and bounds, not even comparable. Why? Because it turns out there's biological differences. I know, shocking, folks. Hopefully I don't get canceled and kicked off the air here for propagating hate speech. But it's amazing that there are actual biological differences between men and women. I know, what a wild concept. What a wild idea. That's how the Supreme Court came down on that. Great news there from the high court. All right, a couple of other decisions as well. The Supreme Court also on Tuesday struck down limits on coordinating spending between candidates and political parties, which likely serves as a boom for Republicans as the GOP seeks to retain its majority in Congress. This is over at Breitbart. They write, the Supreme Court's ruling in the National Republican Senatorial Committee versus Federal Election Commission removes limits on coordinated spending and gives candidates more direct control over a larger amount of money being spent on their respective races. This ruling serves as a loss for Democrats who have argued that eliminating the limit on spending would give more power to larger donors. Justice Brett Kavanaugh wrote for the majority, wrote the opinion that the limits are a severe infringement on the First Amendment protection of political speech. He wrote in part in the majority opinion, to uphold the political party coordinating expenditure limits here could therefore help consign political parties to continued second-tier statuses as compared to outside groups. Weaken political parties distort the political system. National Republican Senatorial Committee Chairman Tim Scott from South Carolina and National Republican Congressional Committee Chairman Richard Hudson, who's a congressman here in North Carolina, said in a joint statement, "This is a decisive First Amendment victory and a major win for the integrity of our political system. The Supreme Court made clear that the federal government has no authority to place arbitrary limits on how political parties support the candidates that they nominate. By striking down these unconstitutional caps on what is called coordinated spending, the courts have restored core political speech and ensured that parties can compete on a level playing field. We are ready to fully support our candidates and put them in the strongest possible position to win in 2026 and beyond. So that was essentially most of the reaction there on this case, removing these limits and allowing major political party funds like the National Republican Senatorial Committee, the National Republican Congressional Committee to spend and coordinate with candidates, which is something that in the past they were not able to do. So this is a huge win for political parties. And the interesting thing about this is good. It should be as good as it is for Republicans, for Democrats. This is not just an issue dealing with the GOP. This is an issue that should benefit both parties. Yet Democrats, surprise, surprise, on the wrong side of that issue. Also, the courts this week issued another opinion in a case known as Trump v. Slaughter, which was a closely watched case involving the president's authority, not President Trump, but overall the president, whoever that may be, authority to remove members of independent federal agencies. The justices on Monday voted 6-3 to uphold President Donald Trump's decision to fire Rebecca Slaughter, a Democrat commissioner on the Federal Trade Commission, before her term ended. The Supreme Court held that presidents have free rein to fire agency heads at will, despite federal law that requires causes for such dismissals. The court overturned Humphrey Executor, the 1935 case in which the Supreme Court had upheld that the FTC's removal provision historically. This ruling has served as a legal foundation for independence of many federal agencies. The ruling dramatically expands presidential power and came alongside some other decisions on the firing of former Fed Governor Lisa Cook. This is another big decision, one that, again, I also don't think is highly controversial. The president of the United States, regardless of who it is, right now it's a Republican. Previously, it was a Democrat. In the future, it will once again, in all likelihood, be a Democrat at some point. It, to me, makes sense that the president of the United States is able to fire members of independent agencies like the Federal Trade Commission. Why would that not be the case? Why would the president of the United States, regardless of who they are, regardless of their political party, why would they not have the power to fire these individuals? I mean, it makes absolutely no sense. And of course, because Trump is in office, this is such a big deal. Because the president of the United States is the evil, awful, terrible orange man, this is a huge case. I've never understood this premise. When somebody wins an election, like President Donald Trump does, or Barack Obama did, or Bill Clinton did, or George Bush, whoever, any president. Notice how I didn't say there, Joe Biden. Wink, wink, nod, nod. If a president wins, they should be allowed to surround themselves throughout the federal government with individuals that are marching by the same drum, individuals that are pushing the same kind of issues forward, right? It's you build a team around you so that you can all run in the same direction. This is not a controversial issue, and a major win for conservatives in this 6-3 ruling upholding the president's decision to fire former FTC chairwoman Rebecca Slaughter. We'll be keeping an eye on all of these decisions and some of the ramifications of those right here on the Nick Craig Show. Back to the state capitol here this morning. The North Carolina General Assembly unveiled a 634-page, $34 billion budget yesterday as that was read into the North Carolina House. Votes are expected today on that. First votes in the House. That'll be happening around 1 o'clock this afternoon. And if all goes to plan, which hopefully it will at this point, that will set up by the end of this week, Governor Josh Stein having a budget on his desk. The million-dollar question, will the governor sign, veto, or allow the budget to become law, notwithstanding any action from him? That's what's very much up in the air. I'll be keeping a close eye on the General Assembly today. I would suspect that there's probably going to be some pretty fiery remarks on the House floor this afternoon. I'll be publishing those up on my social media at Nicholas M. Craig, and we'll dive into all of those details of the state budget coming up tomorrow morning right here on the Nick Craig Show. Well, that's going to do it for a Wednesday edition. Thanks to the law group here in Wilmington for their continued support. 910-251-6088 or lawgroupnc.com. The Nick Craig Show streams live weekday mornings, 7 a.m., YouTube, Rumble, X, Facebook, is available 24/7 in your favorite podcast app, and is heard weeknights, 9 to 10 p.m. on WBT Radio in Charlotte. That's going to do it for a Wednesday edition. We're back here tomorrow morning on The Nick Craig Show.